So, but if it's unduly burdensome, we can deny it. We can deny it if we don't have the record, okay? Hey, I want the ambulance report from this date. Well, it turns out Northfield was the treating agency, not us. We don't have it. We can deny it. And the other is if the information is exempt. If FOIA says we don't have to provide it, we can withhold it. Now, we may need to redact the record. Sometimes we can withhold it in full. But those are the only reasons we can withhold. So what information is exempt? We talked about it for a long time this morning. The information protected by HIPAA. If it falls into that health information that is not de-identified, it's somebody's medical record, we don't have a valid HIPAA release, and HIPAA says we can't give it out, then under FOIA we can't give it out. There are a slew of other exemptions. We're not going to get into them all. There's a lot of things we may not have to give out because they're exempt, but for your department, this is the most important one. So here's a little quiz. You have personal cell phones. The village does not buy a cell phone for you. And you're sending text messages to each other, or you're sending an email for that matter on a Gmail account or something to each other. And you send a text message to another paramedic. Is it a public record subject to FOIA?
If it pertains to public business.
Okay, so you say if it pertains to public business, I would agree with that. It has to pertain to public business. If it's, we want to grab a beer Saturday night, that doesn't pertain to public business. Or if it's a union issue, you're talking about a union meeting, not a public record. It doesn't pertain to public business. However, let's say it does pertain to public business. You know, I know that you sent a text message earlier asking the lieutenant, you know, saying, we have training, are you coming, or whatever it was. That pertains to public business. It involved this.
She has Mrs. Clinton.
Okay.
Yeah, you just delete them. You'll be fine. You delete everything.
Is it subject to FOIA? Those text messages you sent on your personal cell phone,
That's it.
Yes,
they are.
like those, like when Kuto was caught taking pictures back then.
Right. They are. Understand that if it deals with public business and it's on your personal phone, just because it's on your phone or in your Gmail account.
But how could they ever
Well,
find
okay,
that?
so this is a fairly new thing. We used to think under the law that they weren't. If we didn't have it on a server, we don't have it. So, Laquan McDonald, in that case in Chicago, where officers shot and killed, I think he was a juvenile, 17-year-old or whatever he was, 16-year-old. And CNN submits a FOIA request to the city of Chicago. CNN says, I want all text messages sent on personal devices by the officers involved. And they were looking to see after the incident, perhaps they said something that was incriminating. So, the city of Chicago denied the request, said, well, it's not in our possession or control, not subject to FOIA, your FOIA is denied. CNN then went to the Attorney General, who looked at it and said, nope, it's a public record. They said, you're a public employee, so when you're a public employee, you are the agent, the arm of the municipality, therefore when you have it, it's in the possession and control. And as an employer, the employer can say, hey, you need to, as a condition of employment, need to turn over to us all the public records. And so they said, that's a public record, subject to FOIA, have to turn it over.
What if I don't have it?
Well, if you don't have it,
But
you
I
don't
had
have it.
I had it, but I don't anymore.
Now, if you did and you deleted it, it could theoretically be a Local Records Act violation. Because remember, records, we must retain public records. We have an obligation. You cannot just destroy public records. So it may be a Local Records Act violation. Now, if you don't have it under FOIA, we can't turn over what we don't have.
Right, but how would they, I mean, unless you admitted that you had things, how would they ever get a
So
hold
I
of
got this question yesterday, and I'll tell you, the honest answer is if there's a lawsuit filed, then you get a subpoena. And even if you don't have it anymore, they can go to your cell carrier. But here's the scary part with it, is you say to us, hey, I don't have any records. And we get sued. And, you know, because the CNN thinks we do, or whatever resident thinks we do. And the court issues a subpoena, and it goes to your cell carrier, and all of a sudden, here are all the text messages you sent, all about this incident, and you told us you didn't have it. Well, now there's an employment problem because you've lied to the village, if you did have it. Or you possibly, if you said you didn't have it now, all of a sudden, you lied to the requester when you denied it, and you improperly denied it, and now you could be in contempt of court, and there could be all sorts of penalties there. So simply saying, that, when we ask, if you have something, you go, I don't have it, if it's true, if it's not true, that's a problem. If you deleted it, again, could be a Local Records Act problem. I'll tell you, as an attorney, I've seen it, because I've had to go through and review emails and text messages. What's scary is, think about all the text messages you sent in your life. I think about the ones that I've sent, and I will tell you, people aren't as careful about the wording. They crack a joke, something that seems innocuous at the time. Have you ever sent an inappropriate text message? That could come out. Think about if you actually send a text message about a patient that says, get a load of that incident, or, what a moron, or something about, you see a patient, boy, that patient was, good looking, or whatever it may be, in the wording you use, that comes out publicly, it's really bad for the village, it's bad for you, it's embarrassing. A joke that seemed funny at the time, 6 months later, sarcasm doesn't always play well. But this is what happens, and the reality is, whenever you, if I'm scaring you a little, that's good, you should be worried about it, is your texts may not be confidential and secret. So the best advice I could give you is don't text involving work-related issues. Now, I'm not going to say if there's an emergency, you need to track somebody down. Hey, I tried emailing you, couldn't find you on the village email. Or, what's going on? I'm not saying never send a text. There may be situations where it's prudent, but understand that every time you do, it creates this problem. And most of the time we're texting, we don't need to. So pick up the phone, send an email on the village email server. But these are real issues. It's also, I'll tell you, if you have it, it's a pain to deal with and pain to get. So just be very careful. So this got a lot of discussion yesterday. So I don't know if anybody has any other questions about this, or if you're surprised by this or scared by this. So, okay. So best thing again, be careful. And remember, and this was the slide you missed at the beginning that I showed of people sending selfies. This is how things like this come out, and this is how people get caught for HIPAA violations too. A text message may be a HIPAA violation, and could be a felony. So, other practical tips involving FOIA. Just remember with FOIA, assume whatever you write about work-related issues, it's going to be public. Before you type it up, put pen to paper, just be careful what you say, because assume it's public. Simply putting something, a label that says confidential on the email or whatever record, there is no exemption in FOIA that says if you label it confidential, it's confidential.
How about draft?
Maybe, maybe not.
It depends.
It depends. There is an exemption for draft in FOIA, but it only applies to certain records in certain circumstances, and it's very technical. But just because it says draft doesn't mean it may not ever come out. So assume it's going to be made public. The other, and this is not, there's no legal reason you can't have long email chains, it's just a practicality issue, is that the bane of my existence and your FOIA officer's existence is when somebody says, I want all records relating to this matter, and then we go and get them on the server, and not only do we have 600 emails, but each one is a chain. Meaning, instead of looking at one paragraph or the one sentence when you responded, for each 600 emails, I have to read through 22 pages. So if I make a redaction on something because it includes personal health information, I have to do that on each one of those emails because it's embedded in that chain somewhere down the line. So it makes the redacting job incredibly painful. It also just means reviewing is so much harder, because if I catch it in 600 emails, if I catch it 599 times, but miss it on just one, we have a problem. So the best thing is, if you're just in general practice, if you notice that this is the 8th person who's hit reply or reply to all on an email chain and it's getting big, start a new email. It'll make your FOIA officer's life that much better.
It's not unduly burdensome.
Depends on the issue, not necessarily.
We don't mind if our
If
FOIA
Marty has to do that,
Yeah, we.
I do. I will say
I
this,
do
the other
too if
thing
Marty's
is,
off, so.
what? Also use prudence in the sense of, if you have a big incident in town, okay, and this happens with a police shooting incident. It could be whether a celebrity gets injured. Whatever it may be that you're dealing with, a giant fire that burns 4 houses, and you know it's gonna be
Hey,
a
hey,
big
hey,
immediate thing.
gotta use that example?
Hmm?
You gotta use that example?
Not saying it's your fault. But these things, you know, if you think that that there's a chance that this is gonna be a big deal, just remember, again, there's more likely we're to get a FOIA request about it. So again, be careful, keep these tips in mind. And sometimes picking up the phone is a better idea. So, last thing I'll tell you is never tell somebody they can obtain a record by submitting a FOIA request. We have to look at the record, process it, see if it's exempt. But this happens all the time where somebody said, oh, can I get this record? And you go, sure, submit a FOIA request. And then what happens is we get the FOIA, we process it, the record, it turns out we cannot provide because it's exempt. The law says we can't give it out or whatever, we deny it, and then the person goes, wait a minute, firefighter so-and-so said I could get it. Police officer so-and-so said I could get it with a FOIA request. So it's just a customer service issue of setting expectations, but then they get really mad at the FOIA officer at the village and at you, because now they can't get the record they thought they were gonna get.
Perfect.
So that's FOIA, and the last thing I wanted to discuss.
Can I ask a question?
Of course.
When does, fire investigations fall, where do fire investigations fall under FOIA?
In terms of,
You know, the homeowner says, I want a copy of the investigation. I know
So-
we've been less willing to share those at times.
which I get. So here's what's difficult.
Please call the Bureau, Captain Banks, please call the Bureau.
It's like Scott, that he said.
What makes it difficult is for ongoing investigations, law enforcement's really protected. Police have exemptions. Those same exemptions don't necessarily apply to you. I would say it also depends on the investigation. Is it related to a potential criminal matter? Then you're more likely to be able to withhold. If it's draft, there may be reasons, and it's a very, again, if you get those, let's talk, because there may be all sorts of exemptions that we could try to use. But it's not as if there's an exemption that specifically says fire department investigations. So we may need to be creative and see what's available. Maybe we can find ways to withhold certain things and not others.
So, a lot of times it comes from the investigation agency or someone looking for subrogation. So, I guess that it doesn't make a difference who's requesting it, it's just what the context of the report is?
Right.
The context?
Right, the requester itself doesn't matter so much as it is what's in there, and so, and the status of your investigation and all that. So again, contact us, and we can, particularly on anything sensitive that you're worried about, and we can see what applies. And sometimes, again, we might be able to withhold a lot of it, maybe not all of it, but we'll have to, it's really fact-specific, case by
Obviously, there's
case.
personal information in there.
Right. So the other type of requests that we get are subpoenas, and I wanted to talk about this today because the fire department, other than the police, who testify all the time in their criminal cases, you are the ones who get subpoenaed more often than anybody else in the village because you're first responders. Whether it is to a criminal matter, whether it's to a personal injury matter where two drivers are suing each other, you're a first responder, you see the damage, you're there for the people to make their first admissions. So attorneys naturally are interested in what you say. So who here has received a subpoena before? Who's testified either at a deposition or trial? So, and if you haven't, it's coming at some point, I promise. You will not have a career as a firefighter without going through this. So let's talk about what you can and can't do in terms of what information you give out, and also how to prepare if you have to give testimony. So understand there's really 4 types of subpoenas. Subpoenas duce tecum, which is a Latin term, and basically that just means a subpoena for records. And usually the wording of the subpoena is a little unclear, because they'll say, you need to appear on this date, and then they'll say in small print, except if you provide the records, listed in the attached rider or something like that. And it's a subpoena for records. There are subpoenas for depositions. So, A deposition, if you haven't been to one before, usually happens in a conference room, either here or in a law office. There'll be a court reporter, somebody who's a stenographer taking down every word you say, and the attorneys sit opposite you, and they ask you questions. You're under oath, and they'll say, you know, did you respond to this traffic crash? When you got there, what did the patient say? And so forth, and they'll ask you questions, and it's usually in preparation for trial. They're trying to find out what you know. There's a trial subpoena, meaning you have to show up in court for a hearing or a trial before a judge. And you go down to the courthouse, and they'll call you as a witness, and it's, in some respects, just like TV. And then there's what's called the grand jury subpoena, which I'm not going to talk about further, just understand there's a fourth type. And you know, if you get a grand jury subpoena, it's because somebody's investigating a criminal matter. You might have information, you might need to appear before a grand jury and testify. If you get one of these, let me know, and we can discuss it. So importantly, let's talk about the subpoena duce tecum, so subpoenas for records. It does not trump HIPAA. A lot of people think it does. It looks official, it's a subpoena, so I gotta comply. Wrong. It's a subpoena. It's one thing if it's written by a judge and contains certain information, but generally speaking, you get one of these subpoenas, you can only give out an ambulance report with the HIPAA release from the patient or one of these other ways. So usually, and I will tell you this, it happens time and time again, is attorneys are silly because they don't provide it. I don't know why. I don't know why 70% of attorneys, when they asking for this, always leave out the HIPAA release. But we're gonna have to call the attorney and say, we can't process this. I can't tell you even if we have records. I can't process this till you get me a valid HIPAA release. Then they'll go do it. I've never had somebody really argue with me, but we're gonna have to ask for that. The other way we can give out HIPAA protected information is a HIPAA protective order, which means instead of coming from the attorney, it's an order from the judge, and it usually says HIPAA protective order, and it says you can give out the records to the attorney. However, the attorney is bound by confidentiality and cannot use and share the records in any way other than for this case. So you might get one of those with a subpoena or a letter, and if we have one of those, we can give it out. The last is something called a satisfactory written assurances, which is basically a form that the attorneys fill out, and this often happens in a situation where the offender or the defendant or whatnot can't be found or can't be reached. They've tried for months to try to get a HIPAA release and they can't do it. And it's basically an affidavit from an attorney saying, I've taken the following steps and have not been able to secure one and I can't reach the patient, and so forth. These are rare, these only happen occasionally. Importantly, no, just because you get a subpoena, you can't give it out. Call me and we can review what we have. Depositions. Now, I know you're not processing those subpoenas, so that Marty does a lot of that. But this is something that you may get, which is they want to depose you and sit you down and take your deposition. We may need to get a HIPAA release. If it's a patient and they're going to ask you all about it, you can't just show up and start sharing information. So call me, I'll talk to the attorney and say, hey, we're happy to come down and give a deposition, but can you, before we do so, can you send me a HIPAA release? So once you get one of these subpoenas, call me right away so we have time before the deposition to get it. Also, call me because we can arrange a more convenient time and location. They'll just pick a random date and say, I need you at 1 o'clock on November 3rd in my law office downtown in Chicago. Well, what happens if you're not working that day? That kind of sucks to give up a day to go do it. Or it's all the way in Chicago that you're going to have to not only drive all the way down there, but now you're on duty. You have responsibilities here, and you're going to lose most of the day because you're doing this deposition. What I can do to the attorney is say, hey, number one, you're going to come to the village. We're happy to do it. You have to come here, and they'll do it. And second is we'll pick a day that is convenient for you, one that you're on, when you're on duty. And so it'll be an hour when you sit in our conference room and you do it. But call me so we can arrange that.
On the subpoena for records, why do a subpoena for records if you need a HIPAA release? Why not just do a Foia without a HIPAA release?
Well, oftentimes they do FOIAs, but the benefit of a subpoena is there are certain things that we can give out pursuant to the subpoena that we wouldn't otherwise. So for example, private information. Under FOIA, we aren't gonna give people's home address and home phone number. Under a subpoena, we do. So they can get more information through a subpoena.
But if you have a FOIA and a HIPAA release, we should be able to give it out the same information, right?
Depends what the release says. So,
An attorney that says it depends, that's so
yeah, I know.
Lot 29 and 20,
So,
truck 14, email 29. Another medical,
You guys still filming?